Hello and welcome to Quadcast, Quadrant Chamber's weekly discussion forum. Not weekly, sorry, fortnightly now, discussion forum looking at news, hot topics and legal developments in the world of commercial litigation. The format is very simple. Drink, talk, chat. Drink, I've got a delicious Peroni zero alcohol beer. Talk, we're going to talk about a legal topic each week. This time we are looking at illegality and two cases that are pending before the Supreme Court. And chat, we want you to join in. You can send us questions and comments by joining in on the YouTube chat function, or you can email us. That is quadcast@quadrantchambers.com. And hosting Quadcast with me this week, the team are back. It's Poonam Mawani, Claudia Wilmot-Smith and Joe Sullivan. So let's just catch up, see what people have been up to. Poonam, what have you been up to this week?
Oh, it's been very exciting here. Nearly every member of the family has lost 2 or 3 pounds this week. 2 or 3 pounds worth of hair, that is, because I had a hairdresser come to the garden and she was here for about 5 hours, chopping all my men's luscious locks off. Yeah, Joe, I was just looking at you. Perhaps you should consider getting a hairdresser in at some point soon. But yeah, so that was the real excitement. Joe, what have you been doing this week apart from not cutting your hair?
Well, no, I've just had my hair cut. What are you? Bit awkward. No, I haven't. But what I have been doing is basking in the glory of Liverpool becoming the Premier League champions. Fully anticipating that they're going to break the all-time points record, most victories. It's been a long time coming, but it feels good.
I thought you were going to talk about your new Twitter crush, Elon Musk, who is apparently backing, or maybe backing, Kanye West's presidential bid.
Well, I think he ended up being Paul's Twitter crush, not mine.
Oh, yeah. Well, it turns out he's not only pro Lord Sumption, he's pro Kanye West running for president. So that's what I learned this week. How about you?
Well, what else have you been
How about your haircut, though, Paul?
I was so kind of you to notice. So kind of you. Yeah,
So
I also tried turning my Yorkshire pudding recipe. You remember the triumph of my Yorkshire pudding success to a vegan recipe. I thought, how hard can that be? I'll just use egg white substitute. Disaster. Total disaster. Just a flat, gooey mess coming out. So
it's a pretty stupid idea, Paul.
Anyway, are we done on the Claudia? Yeah, I don't think you've said what you've been up to this week.
Following Kanye West presidential run.
Oh, sorry. Yeah. Okay. Right. So we are looking at illegality. And as I say, 2 cases before the Supreme Court, factual issues arising in the Shagang case and legal issues in the Stoffel case. So we thought we'd look at the facts first. Shagang is a case and a half. And Poonam, you're going to tell us all about Shagang, I think.
Yeah, so starts quite boring. It's a charter party dispute. Owners are owed money by charterers, and actually they're suing the guarantors in this particular piece of litigation. The guarantor's defense was that the charter party was procured by bribery, that the owners had bribed the charterers, so they said unenforceable and you can't claim against us. The way the guarantors were able to plead and argue the bribery was that the participants to the bribe had been arrested in China and were being charged with corruption. And while they were incarcerated, they had all given confessions about the bribe. So that was the evidence. And what the owners said in response was, no, there was no bribery. And also, don't admit the admissions, the confessions, don't let them into evidence, don't give them any weight, because they were procured by torture. So it was all quite juicy stuff. But let me just tell you, as I said, we've got to talk about the torture bit, but also let me tell you what the bribe was. What the allegation was that someone from owners gave money to a chap, I'm going to call him the son, and the son's father was with charterers. So the son says to his dad, I've been given this money for you to enter into this charter party. And Daddy is an upright citizen and says, we can't do that. We can't take the bribe. It's got to go through the normal channels. Return the money. So he thinks the money is returned, but son hangs on to the money and also takes another installment of the bribe, which his dad doesn't know about. Okay, so first thing, let's talk about what the Court of Appeal said about the bribe. This didn't go to the Supreme Court. They did some deal that it's up for grabs back at first instance if we get that. So the Supreme Court, or the Court of Appeal say that, and it's clear law, that if someone bribes someone in your family, then that's good enough. It doesn't have to be you. The benefit comes to your family or someone very close to you. That's still a bribe. And they said, so the money's come to the son, and there is, per Christopher Clark in one of the Novus ship cases, once you know there's been a bribe paid, there is, wait for it guys, an irrebuttable presumption that the bribe has induced and had its effects. They're irrebuttable, not like in fraudulent misreps where it's rebuttable, irrebuttable. So any thoughts on that, guys? I mean, the money went to the son. The dad thought it's been returned.
The irrebuttable presumption arises because you've established the conflict of interest and you've established the benefit, and those two factors together mean you don't have to go any further. But if you don't establish the conflict of interest, it seems to me you haven't got the building blocks for the presumptions. It just seems to be wrong.
I mean, in a sense, the dad doesn't know about the bribe because he's said the money should go back, and so he doesn't even know about it.
Is it just an evidential point, though, that they just say, well, if you pay a bribe to a family member, it's going to be very difficult to prove that it was passed on, but we just have to, as a matter of policy, assume that it was.
All right, you might try and work on burden of proof, but I don't think you can just say, if I give money, someone gives money to my husband and I know zero about it, he doesn't even tell me about it, how am I bribed?
Isn't there another point with bribery? You have to show that the bribe is such that it would affect the mind, the decision-making power of the reasonable person. So a de minimis, like, for example, corporate hospitality is not a bribe because it's reasonable, it's low level. So you can just get out of it that way, surely. You say, well, because the father didn't know about it, it wasn't going to affect a reasonable person.
Well, we're all on the same page. I thought that was just balmy by the Court of Appeal. But then here's the other bit that has gone to the Supreme Court. Knowles decides, and it doesn't matter what order he does it, Knowles decides that he cannot be satisfied on the balance of probabilities that torture occurred. So therefore, he allows the confessions in. I mean, if they'd been brought by torture and that illegality, he'd have thrown them out of court. So he decides he can't be satisfied torture happened. So he allows the confessions in. But then when he's weighing up whether he is satisfied that a bribe occurred, and when he's weighing up the confessions, he says, the fact that there might have been torture also gives me pause to not rely on the confessions. There's various other factors, but the fact that torture might have existed is one of them. So it goes up to the Court of Appeal, and the Court of Appeal, the three of them in one unified judge, no, he's gone totally wrong on this. Once he's decided that there's no torture, he can't allow torture to infect his views. It's got to be put out of his brain. Of course, the argument contrary is, it's not that he found there was no torture. He found that he couldn't find that there was torture, which is not the same thing as finding that there's no torture. Anyway, it's gone up to the Supreme Court. I watched it all, and I think I know what's going to happen. But where do you guys stand on this binary point about the torture, chucking it out, letting it infect? Let me go to Joe first. I know Claudia's gagging, but I'm going to go to Joe first.
I think the Supreme Court will allow the appeal.
All right.
He says that he's not sure that torture happened. Is it because he thinks that something happened, but he thinks it might have stopped short of torture? Or he couldn't conclude that any sort of wait to procure the confessions happened? Because if he thinks something happened, but it stops short of torture, that's one thing. But if he says, I'm not satisfied that these confessions were procured by wrongdoing, then
the evidence of torture was, insofar as there was evidence of torture, it was proper torture, but he just can't be satisfied.
I think if he's concluded that he's not satisfied in balance of probabilities that happened, then he has to, the evidence is in and he gives it.
It's not that sort of autistic though, is it? Because I agree we have to make findings of fact on the basis of balance of probabilities, the all or nothing. But if you're weighing evidence, I think that they've got to allow this appeal, because I was so shocked they gave permission. So somebody thought there was something fundamentally wrong at the permission stage, which suggests to me that it's going to be allowed.
Well, I agree with the two boys. I think it should be allowed, and having watched it all, I think it will be allowed. Can I just say, we've actually had a message, guys, so we're all aware that there's some terrible lag on YouTube between our mouths.
I think it's been resolved.
Joe, are you going to tell us now about some of the principles of illegality?
Yeah, well, I've actually been looking at a case that is mentioned in a number of the appellate authorities in this area, especially by Lord Sumption. So it's quite interesting to see what was going on. It's called known as the Highwayman case, and it took a bit of finding. Actually, there's no surviving report of this case that everyone keeps mentioning. It was in a case in 1725. But I've found a reference to it in a Law Quarterly Review article from 1893, which itself, apparently the report had already been lost by then, but they found the facts from an 1802 textbook, which was itself a translation into English of a French textbook on the law of obligations. So there may be some element of Chinese whispers in the story, but it's a great case if even 1/10 of it is true. The case was called Everett and Williams, and as I said, it was decided in 1725. Mr. Everett and Mr. Williams were two highwaymen who decided to engage in their enterprise as a partnership. And Mr. Everett felt that Mr. Williams wasn't giving him his fair share of their loot. So he sued him. He issued a bill of equity at the Court of Exchequer. Now, there's a couple of extracts from the pleadings, which are of some...
Where did you find the pleadings, if there isn't even a reported case?
The pleadings are extracted in the article. And I guess they got them from the textbook. So, again, who knows? But they weren't described as highwaymen by the pleader. They were described as litigants skilled in dealing with several sorts of commodities, perhaps euphemistic. And in terms of how they conducted their business, they dealt with gentlemen for divers watches, rings, swords, canes, hats, and cloaks, which were obtained for little or no money after some small discourse with the said gentleman.
Very skilled in their dealings, I guess. Yeah.
Yeah. They had great chat, I think. Anyway, the court had very little hesitation in throwing this case out. Really on grounds of illegality, although that seemingly wasn't the analysis used. The court said that the claim was scandalous and impertinent. It dismissed the claim in its entirety. It issued a warrant for the arrest of the solicitors acting for both parties. They were then brought before the court and fined each for the impertinence of even pretending to bring the claim. The barrister was ordered to pay all of the court's costs. The litigants themselves were hanged. And as a little postscript, one of the solicitors was subsequently himself prosecuted for robbery and sentenced to death. But the silver lining was that his sentence was commuted to transportation. So... yeah.
I heard that he came back, though. He came back from America and started plying his trade as a solicitor again.
Yeah, apparently so, which goes to show that the standards may have slipped.
Joe, I think you've made half that up, frankly. But anyway,
this is
It's a story of redemption.
Yeah, absolutely. And so, in any event, that I think is, if ever a case feels like it's going badly, you need to think about that case and think perhaps it could be worse. Anyway, Paul, you've been looking at some slightly more recent cases.
Yeah, Tinsley and Milligan is a sort of milestone case in the early 90s. Stella Tinsley, 19-year-old young woman, and Kathleen Milligan bought together a lodging house, a boarding house. Stella Tinsley was the owner on the title deeds. Kathleen Milligan, although she contributed to the purchase price, her name wasn't on the title deeds. And conventionally, if you get a situation like that, two parties buy a property together, both contribute, one of them owns it, there's a resulting trust, pretty standard. But the reason that Ms. Milligan's name was not on the title deeds was because they were conducting a fraud on the Department of Social Security, and it was easier if it wasn't provable that she was the owner of a substantial asset. The asset, I should tell you, was 141 Thomas Street in Abertredare. I don't know if I pronounced that correctly. Apologies if I haven't. Mid Glamorgan. And the purchase was in 1988. And they fell out, of course. And the Ms. Tinsley, whose name is on the title deed, sought possession of the property. And Ms. Milligan said, no, I have an interest in this property, and defended the action. And the point was that the very motive, the reason for keeping her name off the title deeds, i.e. the reason she needed the help of equity and the resulting trust, was an illegal purpose. And the case is particularly interesting because in the Court of Appeal, it was decided that there wasn't a ground to refuse relief, but the analysis depended on the concept of the public conscience, that the public conscience wasn't sufficiently offended to deny relief. In the House of Lords, it was split 3-2. Lords Brown, Wilkinson, Jauncey and Lowry agreed that relief should be granted. The illegality didn't taint the transaction sufficiently. Lords Gough and Keith disagreed. And their analysis was this sort of all or nothing, that okay, this was low-level fraud and it was all sorted out, but it could have been so much more serious. It could have been a terrorist purchase or something of that nature. And so they took the view that really you can't have any situation, a bit like with the highwayman, you can't have a situation where the courts are helping, giving any assistance to any criminal endeavour.
That was the minority.
The minority, but the majority said it's fine. And this is sort of a theme we'll see develop. But Claudia, you've got the latest case, decided case anyway, Patel and Mirza.
Yeah, well, the latest so far. It was a decision of a 9-member court. So a couple of years earlier, Lord Neuberger had said in a case called Belter that the law of illegality is a mess and we need a 7 or even a 9-member court to look at it properly. And in Patel and Mirza, 9 members of the Supreme Court got together purportedly to look at it properly. And really, I'm not sure it made things better, certainly didn't make things clearer. It was a straightforward claim in unjust enrichment in one sense. Mr. Mirza had some very good insider information, apparently, from RBS. He knew exactly what they were going to do following a government announcement. And so Mr. Patel gave him £620,000 to bet on RBS shares following the government announcement. Except the announcement was never made. So Mr. Patel said he wanted his money back. And he said, total failure of consideration, I'm entitled to restitution, which is true if it were not for the fact that insider trading is illegal, and this agreement whereby they decided to do this insider trading was itself a criminal conspiracy. So there's Tinsley and Milligan reliance test. Well, Mr. Patel had to rely on his own illegal conduct to found his claim, because he had to say the consideration was this criminal conspiracy. But the Supreme Court didn't say that, that all 9 of them said that that wasn't a reason to deny the claim. There was a divide. Lord Toulson gave the lead judgment, and he said we need to revisit the law of illegality and we need to look at it afresh. And he had this approach that Professor Burrows had taken, right? So Professor Burrows had said, now Lord Burrows, you can either formulate a rule and apply this rule uniformly, in which case it's quite a difficult way, like what rule do you formulate? And he attempted and he couldn't find one that he was satisfied with. So he said the better approach is to use a range of factors which are to be applied from case to case to decide whether a remedy should be granted or not, really. Professor Burrows had 8 factors, but Lord Toulson narrowed it down to 3, a trio of necessary considerations, not just for restitution, but for any claim involving illegality. He says you have to do 3 things. One, you have to consider the underlying purpose of the prohibition transgressed and the public policy that says the relevant conduct or agreement is illegal. Two, any other public policy factors that go the other way, or which may be rendered ineffective by denying the claim. And then three, there's this proportionality thing. You have to say, well, would denying the remedy lead to overkill? Bearing in mind that it is the job of the criminal courts to punish, it's not the job of the civil courts to punish.
Is this the third one, the overkill? Is that harking back to public conscience? Is the public conscience idea still there in all three, in some?
Well, they're not really measurable factors. Yes, that might... It's all about public policy, and what he's saying. The effect, and the reason Lord Mance, Lord Clark, and Lord Sumption were very firmly against it is they said essentially this trio does reintroduce this public conscience test. Exactly. Not just in the third one, though, Poonam, it's really all three. They say you basically left, but you've said that there are these three policy to apply in every case, but the effect is that, I mean, you know, how do you actually weigh them, measure them? Really, it's the judicial discretion ultimately. So they didn't like that approach, but it was the lead judgment, and it's not surprising in my view that it's gone back to the Supreme Court. And I think in Stoffel and Grondona, Poonam, you're going to talk to us about reconsidering Patel and Mirza. But before we do, I think we have a case study. Joe, have you got a case study for us?
Yes, I do. So the case study, which I think is going to go up onto the screen. A brother and sister, Jack and Jill, they borrow £2 million from their auntie as money bags in order ostensibly to set up a new business trading carbon credits. But in fact, they're using the money to launder the proceeds of a drug cartel that they run. And the $2 million that they borrow from their auntie is secured over a property, Snowy Ridge, which they own, and which a valuer, jointly instructed by them and their auntie, valued at £4 million. 2 months into the loan, another drug dealer offers to buy the property for £5 million, and they accept that offer, relying on the valuation that they've been given of £4 million. But it turns out that valuation was negligence. In fact, the property was worth £10 million. And the question is, can the Weedsters recover damages from the negligent valuer? Now, if those watching would vote, and we encourage you to do so, the address to vote at is www.quadcast.vote. That's www.quadcast.vote. So please do vote, and we'll announce the results later on in the Quadcast. Now, I think, Poonam, you're going to tell us about the hot news on this area.
Well, so this is the case of Stoffel and Grondona, which has been heard in the Supreme Court. I assume just a regular 5, but we haven't had the decision yet. So facts are to do with mortgages, which is why I gave you the problem we did. This woman borrows money from Birmingham Midshires as a mortgage loan, and on the basis that she's buying a flat with the loan, and she gives a charge to the company, and she uses the money that they give her to pay the vendor, Mr. Mitchell, who is a friend of hers. And he sends her the documents that she needs in order to register her legal title, in order to get an old charge off the register, in order to get the new charge on the register. She gives it to solicitors that are instructed by the mortgage company and herself, and they totally mess up and forget to register it. So that means she doesn't become the legal owner. The lender's charge doesn't go on it. When she defaults, they can't enforce against the property. They sue her personally for the money. And so then she sues the solicitors for negligence, because she said, if you've done what you're supposed to do, they'd have got it off the property, but I'm not the owner now and I don't have it. They have a great defense. It is, yeah, we admit we're negligent. We admit we totally messed up. But, they say, actually, this was all a mortgage scam. Your friend, Mr. Mitchell, couldn't raise money. So you concocted this whole thing so that you could raise money on the mortgage loan, which you gave to him. It was all a mortgage fraud. So you shouldn't be able to sue me for my negligence. And at first instance, Patel and Mirza, the case that Claudia was talking about, hadn't yet been decided. So it was the Tinsley case that Paul was talking about that was the law. And the judge said, yeah, mortgage fraud is terrible, it's awful, but they don't have to rely on the mortgage fraud to sue. They don't have to plead it. They don't have to say it. They've just got an independent cause of action against the solicitors for being negligent, so they can claim. Goes to the Court of Appeal. Lady Justice Gloucester gives the lead judgment. She then applies Patel and Mirza. And she says, let's look at the trio. So she goes, yes, mortgage fraud is a canker on society, but denying people claims against negligent solicitors isn't going to stop mortgage fraud. So I'm not I'm not stopping that. And there's a really weird bit where she says, in fact, if I allow this claim against the solicitor, it might get solicitors to be more vigilant about whether there is mortgage fraud, which, I mean, to me, it's just bonkers. But anyway, then on the other way around, she goes, the public policy of not allowing it, oh, no, we must let people, we can't have solicitors going around being negligent. So it would be defeating that public policy to deny this claim. And then on proportionality, she just sort of says, yeah, wasn't that bad, it wasn't there. So anyway, it's going to the Supreme Court. And I'm going to ask you guys what you think is going to happen. I'm going to start with you, Paul.
I think that relief should be refused, because I think there's a difference between cases where the beneficiary of a refusal of relief is the criminal and the beneficiary of the refusal of relief is an innocent third party who's not involved in the criminal wrongdoing, like Stoffel. And so I think that relief should be refused. You should be more prepared to refuse relief if the beneficiary is an innocent third party.
So you're just applying a public conscience test here?
I'm applying, I think it should be a proportionality. I think that to deprive somebody relief is depriving them of their Article 6 rights. And I think that that's a serious matter, but it's justified if on the basis of their illegal conduct. And I don't buy the whole thing, that's the role of the criminal courts. I think it's also the role of the civil courts to apply.
All right, that's Paul. Claudia, where are you, honey?
I don't think the negligence or the conveyancing that the solicitors sufficiently connected, the public policy connections, I don't think are sufficiently close to deny relief. I agree with the notion that solicitors shouldn't be negligent, and the mortgage frauds generally won't be helped by relief. Yeah.
Jim?
Yeah, I agree with Claudia. I think that the claim should be allowed in that case, and I think that it is the role of the criminal law to sort out what happens to the money once the negligent solicitor has paid for their negligence. I mean, I can see that it's a hard case.
I'm not saying I think that it should be necessarily. I'm saying that I think if you follow Patel and Mirza, then you would allow it. Yeah.
Would you?
No, definitely, yeah. I agree that should be the result in accordance with Patel and Mirza. But I also think that it should be the result as a matter of policy. If
you were the judge in the highwayman's case, would you then have given judgment for the claimant and say, well, it's let the criminal court sort it out?
Yes.
You would? Yeah,
because otherwise it's just random. Who happens to have the money at the end? That's just completely random. It's not a principle.
It seems odd, though, doesn't it?
Joe, I was going to congratulate you on being right, in my view, on Stoffel. But then you go and say that about the highwayman case. You would let them sue for half their illegal loot.
So I think it's different. I think in the solicitor's negligence case, I think you have a right against your solicitor that they owed you a duty of care.
Right.
They didn't owe you less of a duty of care because you happen to be mortgage frauding. I think in the highwayman's case, it's arguable that, because wasn't he suing for a partnership account?
Yeah.
And so I think it may be arguable that a partnership of highway robbery isn't a lawful partnership, and so therefore you don't have the right to enforce.
So
all right, and I agree with you too. But let's see where our audience are on.
Joe, have you got the results?
Well,
Yeah,
yes, I do have the results, and if everyone remembers the problem, it was whether
we should ask us what we think of the problem, because we haven't done that, have we? We've done Stoffel, but we haven't done our answers to the problem.
All right. Well, I don't know whether the problem's gone back up on the screen, but I'm going to ask you first, Poonam. Do you think that the weedsters should be able to recover damages from the negligent valuer?
Okay, so there's a factual wrinkle here, right, which I didn't pick up at first, but I think I've got that, is that the only reason the valuer was valuing the property was because Auntie Moneybags was lending them $2 million, and that was all for an illegal purpose. So he's kind of innocently wrapped up with that there. And I hear all that, and I take that on board. But since you know my view on the Stoffel case, for the same reason, I would say you have the claim against the negligent valuer.
Right. Claudia?
Yeah, I agree. I mean, I think there might be an interesting Samco question about scope of duty of care, but I don't think the fact that they were money laundering is sufficiently closely connected to any of this to really deny them a remedy.
Yeah, and I guess that Samco point might be we would need to see the terms of the retainer, wouldn't we, to work out?
Yeah. What's the Samco point?
I'm not sure the Samco point. I've thought about this, but it doesn't work, does it? Because Samco's about duty of care. Here you've got a contractual duty, so.
I don't know what the contract says, but interesting, like scope of the duty, whether it encompasses this kind of loss on a resale, because he wasn't.
Even in a tortious duty, then like Samco, it can be constrained by the terms of the contract or defined by the terms of the contract. Anyway, Paul, what do you think on the illegality?
I think I'd refuse relief, because I think here that the illegality is one step closer. And as I say, the professional is totally unconnected with the illegality. So I don't have a problem in letting him off.
But he was just, so the security, because the security for the loan, because he was valuing
but they're getting the loan to
advance money. So you're like looking a number of transactions from the unlawful.
Yeah, but they're getting the loan. The whole purpose of the loan and the valuation is to do the money laundering.
Anyway, that's what we think.
What do you think? You haven't said.
Well, I mean, I think people should always be able to sue in every.
I think Joe would just abolish the doctrine of illegality. That's what it seems like to me.
And I think probably most of the audience agree with me, because 77% of our audience think that damages should be recoverable in that situation.
Well, so it's exactly the same as us, right? 3/4 to 1.
Yeah,
that's true.
Yeah.
So Paul, you're the outlier.
There we go. Good sampling. So thank you very much, everyone, for voting on that. And I think that probably brings us to the conclusion, Paul.
Yeah, I think we've run out of time. We did have another case study, but I think we're out of time now on that. Let me just tell you what's going to happen going forward. So we've got 2 more quadcasts that we are going to do. One on the 23rd of July, and then a special final quadcast on the 30th of July. And it is going to be special. You really, if you've watched it, you've got to tell everybody who's watched Quadcast, any of the episodes, tell them to watch it, because we've got a few surprises for you. But the next one on the 23rd of July, we're going to do a breach of warranty workshop. Breach of warranty claims are on the increase. I've already seen them coming in the light of the COVID crisis. And one of the most important points of breach of warranty claims is the notification provisions. It applies not just in breach of warranty cases, it applies sometimes in insurance policy claims and the like. So breach of warranty workshop in 2 weeks, notification clauses, a whole program on notification clauses. There's lots of law to get through. And then at the end, the last quadcast, the 30th of July, that will be on exclusion clauses. There's a recent case, Mr. Justice Foxton decided in the Commercial Court, 22nd of June, CNM versus VCREF. And it's looking again at Canada's steamship, quite a few cases, and he pulls it all together in the judgment. And we're going to look at that and work out where the law is as matters stand. That leaves it just for me to say thank you to Emily Saunderson, who produced the show, and our long-suffering live streaming broadcast tech person, Ben Jacobs, Fish Eyes Production, who's managed to steer us through the problems this week.
And the audience who stuck with us through the problems this week. Thanks for anyone who's still watching.
Absolutely. So thank you all for watching, and we'll see you again next time.